Let me know when we're ready, Catherine.
Bring people in now.
Good afternoon. Welcome and thank you all for joining us for what will surely be a fantastic and insightful presentation. I'll say a special welcome to the mentors and mentees participating in the DBA STEER program. It's great to see everyone reassembled after our July break, and we look forward to closing our program strong this fall. If you are participating in STEER, please stick around for a few announcements and reminders after today's CLE. Kelly Henson and Bill Cobb will talk with us today to give us some guidance on how to avoid malpractice suits and grievances, a topic that is near and dear to all of our hearts, I believe. Kelly is a litigation partner at Carrington Coleman and also serves as the firm's general counsel. Her practice includes defending lawyers and law firms in professional liability cases, as well as serving as an expert witness on professional liability and attorney's fees matters. She is also vice chair of the Board of Disciplinary Appeals, which is a 12-person board appointed by the Texas Supreme Court that hears appeals in attorney grievance cases from around the state. Kelly has consistently been recognized as a super lawyer, one of D Magazine's best lawyers for professional liability defense, and one of the best lawyers in America for commercial litigation. Bill Cobb is one of the founding members of the law firm Cobb Martinez Woodward and devotes a large part of his practice to defending lawyers in malpractice cases, as well as administrative disciplinary proceedings. Best Lawyers named him the Dallas-Fort Worth Region's Lawyer of the Year for legal malpractice defense in 2017 and again in 2019. A fellow of the American College of Trial Lawyers and member of the American Board of Trial Advocates, Bill has been included among the Texas Top 100 Super Lawyers a dozen times. So between Kelly and Bill, they've probably seen almost everything when it comes to the kind of conduct that gets us lawyers into trouble. And they have some tips to share so that you can avoid being the subject of a malpractice claim or grievance. Kelly and Bill, I'll hand it over to you.
All right, thanks, Tim. And I apologize, we were a little bit late getting everyone into the room. We were having some technical difficulties with my PowerPoint. So Tim, can you see the speaker slide and now the little monkey slide?
Yes, it's working great.
Okay, awesome. All right. Well, I'm really pleased to be speaking to the STEER group today because, you know, as it says on this slide, the ugly truth is that even good lawyers are not immune to allegations of malpractice and grievances. So it's not just something that happens to, you know, those other guys and something that good lawyers don't have to worry about. Mistakes happen to the best of us, and, you know, wrong allegations get made about the best of us. And especially people who are in solo practices, they're especially subject to things falling through the cracks or grievance being made by unhappy clients. So Bill and I have a few tips to keep everyone out of hot water. And Bill, did you want to kind of talk about the prevalence of grievances and malpractice suits?
Yes, just a minute to get everybody frightened enough to pay attention for the next 50 minutes. That would be great. First, thanks to the STEER program for inviting us and me particularly to talk. This is fun and always a good time to get to do this kind of thing. So I appreciate the invitation and enjoy being here. Yeah, it is interesting. Most lawyers, they don't think they're immune, but they don't think that claims would ever happen to them. Usually the statistics bear a different story, actually. It's really not at all uncommon to be on the receiving end of a malpractice claim or a disciplinary claim. We used to recite a statistic, and I'm not certain that it still holds, but we used to say that in an average lawyer's full career, the lawyer would face 3 complaints, either malpractice or disciplinary complaints, not always in lawsuits, but unhappy clients who make a claim for money or make a disciplinary complaint against the lawyer. And that is a problematic statistic. The second thing is that the prevalence has gotten to be an important concept, and even among lawyers in big firms. There was a May 2020 report made by the 10 leading malpractice insurers for large law firms about claim frequency recently. They do this annually. The last report that came out in May 2020 pointed out that claim frequency is surging and that it's only going to get worse due to pandemic conditions that we face and the way we practice law in the pandemic. But 8 of 10 of those insurers saw more claims in 2019 than in 2018. And 3 of them had double-digit increases in their claim frequency. And maybe more scary is that the dollar amounts have gone up quite a bit as well. So the majority of the insurers had a claim payment in 2019 that was $150 million or more. And 2 of them had claim payments of $250 million or more. Obviously, that's an extraordinary number. Those insurers said that these claims are arising principally from lack of proper communication and documentation and similar issues, conflicts of interest that we hope to talk a little bit about today. So that's where we are.
Thanks. And Bill, your audio is kind of garbledy. I don't know if there's anything you can do about that. If you want to mess with it while I'm talking.
Yeah, you talk a while and I'll see what I can do.
Okay. As Bill mentioned, I think the key to a lot of the things we're going to say is to have frequent and meaningful communication between client and lawyer. As Tim mentioned, I'm on the board of disciplinary appeals. And so we see scores and scores of complaints against lawyers. And I would say 90% of them arise out of the client feeling like they haven't had good communication, they haven't been heard, they haven't gotten updates on the case and whatnot. And so keeping good lines of communications is key in keeping a happy client and preventing malpractice and grievances. And that starts from the very beginning of the relationship, which brings us to lesson number 1 of our 10 and a half tips. And that's to create a thorough and accurate engagement letter. Usually when a lawyer comes into my office, either a lawyer from my own firm, since I'm general counsel, or a client who comes to me in a malpractice case, the first question I ask them usually is, what does the engagement letter say? And, hopefully we have a good engagement letter that answers the question that's being raised by the client. But too often it's kind of a gulp. I'm sorry, I didn't get an engagement letter for this case for X, Y, or Z reason. And it always complicates defense of the matter if you don't have an engagement letter that spells out the 3 major things you need to hit is who is the client? And that also goes with who's not the client. What are you doing? You define the scope of your relationship. And if there are joint defendants, you need to spell out how that relationship is going to work. And so getting those things nailed down in an engagement letter is key. Bill, are you back?
I think I am. Can you hear me at all?
Yes, that's better.
Okay, good. I switched systems on the fly, so we'll see if that works better. Yes, on engagement letters and termination letters, both are important. And it is so typical in a malpractice defense, meaning defending a lawyer that has had a claim brought against him or her. Very often, the defense involves, the reaction of the lawyer involves to some degree that whatever the plaintiff is complaining about, the lawyer will say, but that wasn't my job. that was not part of what I was signed on to do. That was outside my responsibility. And that may well be the case, but the first place that the trier of fact and the litigants look to try to establish that is that engagement letter, and how closely tailored it is, how broad the engagement is described as being, or whether there are limitations placed on it, specific tasks, specific goals that are there. Similarly, and we'll get to this in a little more detail, the termination letter is similar at the conclusion of representation. When you conclude representation, it's good to say so that there's no mistake about a lingering set of responsibilities. Also, note that the termination letters are great client development opportunities to write a very nice letter that leaves everybody feeling good about what happened.
So the bottom line in an engagement letter is cover who, what, for whom, how much, when, and how. So, I mean, we talked about a lot of those privilege issues, who the client is, the fee arrangement. There's a lot of fee arrangements that need to be in writing, for example, contingency fees. And, you know, guidelines from the client. If the client's going to require you to do certain things, get those in writing. And Bill, I think already talked about the termination letters.
Okay, well, let me just add a couple things on there about why they're important. One is our conflict rules are different and apply differently when you're dealing with a conflict with a present client versus a conflict with a former client. And so it can be important to know with clarity whether you're dealing with a current client or a former client. And you all know this, but Rule 106 in Texas deals with current client conflicts is the general rule. And then Rule 109 is the former client rule, which is has a narrower scope and allows the lawyer more leeway, frankly, than Rule 106 does. So it can be important to have this person be a former client rather than a current client if you're looking to take on additional work. Also, the scope of a lawyer's duty is considerably different for a current client and a former client. As you all know, the attorney-client relationship is a fiduciary relationship. And there are certain aspects of a lawyer's performance for the client that carries that fiduciary duty with it. There's not a fiduciary duty to a former client. There are a limited set of duties to a former client, mostly involving preservation of privilege and confidentiality. But the scope of the duty that the lawyer owes is vastly narrowed once you get the client segued out of current client status into former client status. And the termination letter is good to help document that. It's also a good place to clarify on the front end what you do with your now former client's file materials and who's responsible for maintaining those, at what cost, how long they'll be maintained, what your firm's document destruction policy is, and that sort of thing. It's good to put that communication on the front at the time of termination rather than have the client come back 5 years later and ask for their file and you've not told them your policy is to destroy materials after 4 years or whatever your policy might be.
Bill, you want to talk about, in addition to talking about the relationship between the client and lawyer, what about people who you're not representing?
Right, that's also important. This can begin with the engagement letter and should begin with the engagement letter. If you're representing an entity, for instance, entities, of course, don't speak to the lawyer. Some constituent person at the entity speaks to the lawyer. So you have met with and been on the phone with representatives of the entity client. And so in the engagement, it's important to say, I represent the entity. I represent XYZ Corporation. Our engagement letters typically will say the firm represents the client is. I mean, we're very elementary in the way we do things. We have the first paragraph says the client is, and then we say who it is, and then we usually will have an explanation if it's an entity that says the client is not anybody else not named in this paragraph. I mean, it's it's very plain who we're representing and when we're not. So the engagement letter is one time you can do that. Other times that it can become important, depending on what you're doing. Say you are investigating a matter for an entity that involves interviews with the entity's employees. And so you've gone out to the entity's offices and you're in a conference room and you're bringing in a series of employees to talk to. You don't represent those individuals. I mean, you may agree to, but in the typical investigation type matter, you would be representing the entity, not the employees. And you don't want the employees to form a belief that you do represent them. So a writing can be important in that circumstance, or any time that it's unclear. Kelly's reminded me of the importance of doing that sort of thing in estate planning, where if you represent a proposed testator or somebody that's preparing an estate plan, but in the process of that, you meet with multiple family members or have discussions with multiple family members about what's going to happen with the estate. Certainly in Texas, there have been lawsuits where those family members have successfully advanced claims saying, I thought this lawyer was my lawyer or was representing me, even though the lawyer later takes the position they only represented the testator. That can be important. And in Texas, it's vitally important. In Texas, only the client generally can sue, and particularly in estate planning circumstances. Usually only the testator can or the testator's estate can sue the will drafter. And intended beneficiaries of the estate generally cannot. That's been the law in Texas for a number of years after a case called Barcelo versus Elliott. And so obviously critical to know where the line starts and stops between who's a client and who's not. And estate planning is one of those areas where it can become murky if you're meeting with multiple people, but only representing one of them. There is a case that is noted here on the slide called Parker versus Carnahan that was a wake-up call for lawyers. And it held essentially that a lawyer can be held negligent when the lawyer fails to advise a party that he's not representing them in circumstances where that party could reasonably believe the attorney was representing it. So it's kind of a long and multi-part test to get there, but it is a chink in the armor of the lawyer's defense when typically only a lawyer's client has a claim for malpractice. It can be a separate identifiable negligence action for the lawyer to fail to tell someone in those circumstances that that person's not being represented. Circumstances where this might happen may be three people come to your office to form a business. You represent one of them. You don't represent the other two. You form a business. They get into a dispute with each other, and they all claim that you gave them bad advice. Well, are those circumstances such that the two non-clients could reasonably have formed a reasonable belief that you represented them? Perhaps so. In those kinds of circumstances, where there is a limitation on who you're representing, it's good to document that. And then our disciplinary rules have a similar provision, Rule 4.03, that says when you know, or reasonably you should know, that an unrepresented person misunderstands your role, then you make reasonable efforts to correct that misunderstanding. Don't let that misunderstanding linger when you know about it.
All right, that brings us to rule number 3, which is that being the lawyer for both sides is fraught with peril. And I mean, that seems like an obvious tip. You're not going to represent two starkly opposing sides in litigation. But where it gets more tricky is in the transactional context. Lawyers are helpers by nature, they're problem solvers. And so when a group of people comes to a lawyer with a problem, the tendency of the lawyer is often to kind of fix the problem without really thinking about who's my client, whose interests am I really looking out for here. And, it can be that two people come to you and they just want to document their landlord-tenant relationship. and you think, well, I can just draft a document that fairly represents, memorializes the relationship without representing really the interest of one over the other, but you can't do that. When two sides are negotiating, you need to make it clear which side you're representing and who you're looking out for. Lawyers used to like to say they were the lawyer for the deal. They were, putting the deal together, and they didn't necessarily represent any one person. That's not really how it works, and it opens you up to liability from both sides, saying that, you had a duty to look out for them and you failed to do it. In the litigation context, it can also arise when you're representing who you think are, aligned co-defendants or parties who are sort of in the thing together, but a dispute arises between them along the way. And they want you, as the person with the most knowledge and the relationship with both sides, to kind of get in there and find a solution or arbitrate between the two of them. And it's something that's very tempting to do, but it can lead to claims by one or the other side that you didn't adequately represent their interests. Rule 106 is the conflict of interest rule that talks about these kinds of conflicts. Obviously you can't represent opposing parties in the litigation, but then it goes on to give more detail about adversity that's not really direct litigation adversity. And the comments go through and also give more explanation about what it means to be adverse when you're not in litigation. So when you're in that kind of situation, Rule 106 is your guidepost to kind of figure out if you're staying within the lines there. The comment, as I mentioned, talks specifically about non-litigation conflicts and gives some examples about what may be permissible and what may be problematic. But, just the general rule is, if you're representing two people who are negotiating against each other or with each other or adverse to each other, you need to step back and make sure that you can adequately represent both of them consistent with your ethical obligations.
Lesson number 4 deals with the dangers of business deals between lawyers and clients. And it's no secret that lawyers, I think, are probably becoming more entrepreneurial, and the boundaries between law practice and business or our business activity are sometimes, I think, becoming more murky. And so there will be opportunities for business deals with clients, and this adds a layer of difficulty in lawsuits, and there are also some particular legal principles and disciplinary provisions that deal with that. From a practical perspective, remember, the lawyer owes a fiduciary duty to the client, right? Now, depending on the structure of whatever business transaction you're in, or whatever business you're contemplating with the client may not owe that duty reciprocally. So, number one, you've got a functional disconnect when you're dealing with a client in that situation where your duty is perhaps a higher duty or at least a different duty than whatever duty this person owes back to you, depending again on the nature of what you put together. But that's something to keep in mind. There's a specific disciplinary rule that deals with transactions between lawyers and clients, and it ends up coming to a 3-part requirement to avoid discipline in the ethics system, in the disciplinary system. And this rule often becomes evidentiary in lawsuits that arise from these things. And so expert testimony will often measure the lawyer's conduct against this rule to see if it has been complied with. And if not, then that would be the basis for an expert opinion of negligence or a breach of fiduciary duty. But in the disciplinary rules in Texas, we're advised that a lawyer cannot enter a business transaction with a client unless the terms for the client are fair and reasonable and are fully disclosed. And so you can imagine now at a 2 or 3 year remove, how that phrase might become litigated. But whether the interest is fair and reasonable to the client and whether everything is fully disclosed is a test seldom met without controversy. I will say that. Even when the deal is fair, it is difficult to fully disclose everything. Beyond that, you get to the manner that can be reasonably understood by the client. And so by the time of the future litigation, the client will have a third grade mentality and will not have understood one thing that the lawyer said at any point. So you can imagine how that goes. The parts that the lawyer can deal with more directly in these transactions are in paragraphs 2 and 3. One is that the client must be given a reasonable opportunity to seek the advice of independent counsel. That can be handled in your writing in which you are dealing with this potential transaction. You always should include that advice. The harder part is giving sufficient opportunity to be characterized as reasonable. So how much time is reasonable? If you're documenting the deal tomorrow and you've told the client he has an opportunity to seek independent counsel, maybe that's reasonable, maybe it's not. But certainly the more time you can build in and the more direct you can be there, then the better off you are. And then finally, the client in Texas has to consent in writing to this transaction, understanding that you are entering a transaction with a lawyer, and that the consent should also include these other things, that they say that it's fair and reasonable and that they understand the deal. So it's sort of a 3-part test. They get you by disciplinary tests and also is useful in breach of fiduciary duty or malpractice litigation in the future for having met a standard of care.
One circumstance where you might not really think you're getting into the business transaction with a client rules is when you change a fee agreement midway through the representation. Generally, when you have your engagement letter with a new client and you're negotiating what your fee is going to be, they're not your client yet. And so those fiduciary duties that Bill talked about haven't started yet, and you're free to negotiate on your own behalf. But if you get midway through the negotiation or the representation and say the client can't really pay you hourly anymore and they want to switch to a contingency fee arrangement, that is a business transaction with a now current client, and you have fiduciary duties and all the obligations that Bill went through. And so you need to make sure that those kinds of arrangements are clearly documented, because a lot of times, even though the client is the one who comes to you to ask for this change, then, they hit a big judgment. Your contingency fee is bigger than your hourly fee would have been. And then all of a sudden they didn't understand the change, or you force them to make the change against their will, or all kinds of allegations can be made. And so it's really important when you're changing fee agreements midway through that you treat it just like any other business transaction. There's, in addition to the possibilities of a grievance or a malpractice case, there's other pitfalls if you're deemed to be too close to a client because you have a continuing business relationship with them. It's, potential claims of aiding and abetting. And as Bill reminded me yesterday, aiding and abetting is not a recognized cause of action in Texas, but it still gets asserted all the time, and you've got to defend against it. So, if it turns out that this business that you've invested in with a client is a big scam, then you as the lawyer could be charged with helping the client in a fraudulent endeavor, conspiring with the client, etc. A lawyer, often the defense to a claim like that is for the lawyer to say, well, I only know what the client told me. I didn't know it was a big scam, or I didn't know that they were making fraudulent statements to investors. But if you're invested in the business yourself, or if you have some other business role with the client, it's harder to say you didn't know. And it's at least, it makes the hurdle that much higher to prove that you were not involved or you didn't have knowledge of the client's wrongdoing. So the bottom line is that, investing in a client makes the defense of a case more difficult. And, sometimes the temptation will be overwhelming, but really think about the drawbacks before you engage in that kind of relationship.
I guess just one quick caveat there is that when we talk about this issue with lots of lawyers, they get concerned about how far the rule extends. There is an exception for doing business with a client when you're just dealing with normal trade terms within the client's business. For instance, if you represent Acme Paper Company, you can buy your paper from Acme Paper Company on normal trade terms without it being considered one of these problematic transactions. This deals more with when you're going into something new or doing something as a co-investor with that client. Lesson number 5. This is an outgrowth of what Kelly just mentioned about representing companies that are going to public market for money or doing private placements and other things. That's one of the flags you always have to be aware of. When your practice is developed enough that you have the liberty to say no to a client that comes in the door, that's a wonderful day. And I know that's a hard thing for lawyers, and particularly young lawyers, to come to grips with, because we all need all the business that we can get, right? And the prospect of evaluating a client and saying no thanks is foreign to many of us, and it's certainly something that's a learned skill, but it can avoid problems as you go forward. And so we refer to these clients that you really should just avoid if you can as the unworthy clients. There are a number of indicators that can tell you that a client is perhaps somebody that you don't want to represent, that it might be dangerous to do so. And I think Kelly's got some flags to go through.
Yeah, I mean, the biggest check, I think, is just your gut reaction when you talk to someone and you just kind of get an ick feeling, or, you can tell that they're a horrible person. They're asking you to do horrible things to the other side. You can guess that they might turn around and want to be a horrible person to you. People don't generally, change their spots. But our firm, in conjunction with our insurance company, has instituted sort of what we call a yellow flag checklist, that whenever lawyers want to open a new matter, they're asked to answer certain questions that might indicate that the client is problematic. Now, these aren't red flags necessarily. They're not deal breakers, but they're just questions that will cause additional questions to be asked and just more thought into whether we want to take on a particular client. And some of those are, has the client gone through multiple lawyers? If you've got a client who, last 4 lawyers have done them wrong, it may be a problem with the client and not all their previous lawyers. Is the client proposing a business venture that seems outside their expertise or abilities? Even if you have a longtime client who's in the Acme Paper Company, for example, and then they come to you and they say, hey, I want to start a new business selling personal protection equipment, or raising money to start a gaming company. Just something that they've never done before that's really outside their expertise. You may want to give some thought as to whether they're qualified to do that and if that's something you want to get involved with. Oftentimes also a client will seek to kind of glom on to the good reputation of the lawyer in order to make their business scheme look more legitimate. Have the lawyer come to investor presentations, or have the lawyer come to a meeting with the banker, or include the lawyer's logo on their website, in some way, just trying to get a good reputation vicariously through you. That should make you really nervous. Is the client seeking to raise or spend other people's money? I mean, that's not necessarily a red flag. That's how a lot of people make their living. but it is a particularly dangerous kind of client, because when the investors don't get paid back and they come looking for a deep pocket, the lawyer is going to be on the list of people that they go after. And then is the client's business structure unnecessarily complex? When you look at these Ponzi schemes that fall apart at the end of the day, when you go back and look at how complicated the business structure was, a spider web of special purpose entities and shell companies and whatnot that no one can really explain the purpose for, that's a flag that there may be something that's not legitimate about this client. And again, not to say you wouldn't represent them, but it should cause you to ask additional questions and make sure you really understand what the client is, what their business purpose is, what they're doing, and make sure they're doing it legitimately. Similar to being in a business relationship with a client is lesson number 6, which is the perils of serving on a corporate client's board. Companies love to have lawyers as board members. We're hard workers as a group. We're thoughtful, we're smart, we know the law, and so we're often asked to serve not only on corporate boards but on nonprofit boards. And it can be, a good networking experience, and you can get a lot of good things from it. But when the company you're serving on the board is your client, it can cause problems and increase your malpractice risk. It used to be encouraged at firms for lawyers to get on boards because it was thought that it really solidified the relationship between the firm and the company. But I think most firms are rethinking that and developing policies about their lawyers being on clients' boards. One issue is raised in a comment to the ethics rules, and it says that if there's a material risk that the dual role will compromise the lawyer's independence of professional judgment, you should not serve as a director. And it is difficult to keep clear what hat you're wearing if you're a board member. Are you there just as the board member, or are you there as outside counsel? And when you're making decisions, questions can arise after the fact about whether you were really making those decisions as a board member with your fiduciary duty to the company, and making a decision that was in the best interest of the company, or if you were doing something that was going to benefit your law firm, particularly if you're giving legal work to your firm as outside counsel, or you're making decisions that affect the bottom line of the firm as well as the company. There's also a lot of practical problems that I think Bill's got some good insight into.
Well, I do. I recently represented a very good lawyer in another state who worked full-time as a lawyer at his law firm. He also served on the board of a company that was accused of eventually being a pawn in a vast financial scam that you all will have heard of. But the dual roles caused a number of problems at different times in the suit. One, I was fascinated with my client's testimony in deposition when asked why he would be on the board when he was the company's lawyer, and he was very forthright, said to get more business. I mean, he didn't shade that at all. And that's the reason I think that most lawyers would serve on a client's board, is to solidify that relationship and to maybe protect it from outsiders even. So that is a motivation. But from a practical perspective, there's a couple of different issues to be involved with here. Often directors and officers will have insurance coverage through what's called a D&O policy. The lawyer will often should have legal malpractice coverage through an LPL or a legal E&O policy. And those two policies are different. They're written by different carriers. They cover different things, and they often exclude the risks that each other provides coverage for. So in this situation, the lawyer was sued for misconduct, not only as a lawyer, failing to give legal advice that would have kept the company out of the Ponzi scheme, but he was also sued in his capacity as director for having not done the same thing, violating both duties. It led to a great deal of difficulty, even between the lawyer and his firm, who had been named as a defendant. But the insurance coverage issues became paramount. The firm settled the case, and its LPL, legal malpractice policy carrier, obtained a release for the firm and for the individual lawyer, but it was limited to the scope of legal services, leaving him still in the suit for all of his director work. I just suffice to say that caused for some tension in the law firm's partner meetings there forward, with them having sort of left him to fend for himself. It also created a great deal of coverage side litigation between all three, the lawyer, the legal E&O carrier, and the D&O carrier, because of the unusual and sort of unique circumstance there. So that was a bizarre one that arose because the lawyer chose to serve in the director's role. Had he not done that, then the same conduct would have been resolved a lot sooner.
Yeah, I represented a lawyer in a very similar Ponzi scheme, and the same kind of allegations were made. He had the same problems with his insurance carriers. His law firm didn't settle out from under him, but there was a lot of back and forth about who was paying for what was covered, what wasn't. And, the law firm's defense was, we didn't know that this was a scam. And, as with being in the business relationship, the fact that their lawyer was a director with a company made it that much harder to make that argument that they weren't aware of the inner workings of the company.
Right. I'm not a securities lawyer, but I do understand. My understanding is that there can be issues when you have a lawyer serving as a director with establishing in his director's role or her director's role independence, and whether that independence can be maintained when the person also has legal representation and privileged knowledge, and that can lead to enhanced liability or a harder liability situation under securities laws. It can be a difficult task when you occupy both roles. More dangerous for a director who is the lawyer than it would be simply just for being an outside director.
It also complicates the privilege question. As you know, your attorney-client communications are privileged, but your communications as a director are not. And so it can become a real gray area about what hat were you wearing when you sent a particular email or you gave particular advice, and does that make it discoverable? And it's really hard to draw a line between what's business advice that a director might give and what's legal advice, and so that creates a problem as well.
All right, lesson number 7. We're sort of on schedule. Lesson number 7 here is to document strategy decisions so that everyone's on the same page. And this is instinctive with most people. The problem is in the performance in real time can be considerably more difficult as you're moving quickly through your practice. But remember, the lesson to be learned here is that paper is patient. Paper is patient. Paper will be there, assuming we don't have a major IT disaster. Paper will be there even years later when the lawsuit arises, when memories fade or change, and when people become motivated to adopt one version of events or another. So paper is patient, and it's a good practice to put the important decisions in a writing that can be referred to later on. It does not have to be a big CYA letter. although those have their place. But even billing entries, when you're recording time for a client matter, can have sufficient information in them to serve as a record going forward. Met with client Joe Jones, and we decided to not sue XYZ company, for whatever reasons. I mean, that can be in the billing entry. Email can be done almost in real time that documents artfully the status of the matter and what everyone has decided to do. I also think it's good for bringing clarity, not just to the client's thinking and understanding about what's happening, but I find, at least in my practice, when I start writing down what we have planned to do and why, it brings clarity to my own thinking about what we're doing and why. And so it's a useful exercise, not just for covering yourself, but for informing the client and for bringing that clarity to what you all are going to do. A letter, an email, always good practice, and helps to flush out any disagreement or misunderstanding early while it's still remediable, and before the die has been cast, if you will. Number 7 is we're already number 7. Rule 103 is a disciplinary rule that deals with this. It's pretty vague. It says that a lawyer has an obligation to keep a client reasonably informed, and there's the word that we litigate all the time. What's reasonable information about the status of the matter, and promptly comply with reasonable requests for information. There's a few argumentative or room for argument words in that phrase. There are hard and fast rules on certain things. Offers of settlement generally must be communicated to the client. The client needs to be kept abreast of the status of the matter. I'm always amazed at my office. Of course, I represent lawyers mostly, so this is second nature. Every filing with the court is copied to our clients, either incoming or outgoing. And I have found that that's actually a sort of a rare thing in certain areas of practice. It seems to me to be a good idea. It creates an as-you-go paper chain. It helps document that the client was kept abreast of the status of the matter, and helps keep them informed of the difficulties that you're facing in the case, or the advantages that you're achieving. It's just a good practice, I think, to do that. Although I confess it's not universal. The way in which you communicate with a client is also important. And I'll note this: promptly complying with reasonable requests of information. Kelly probably has some stories on this, but in our grievance defense practice, this is probably client complaint number 1, is the failure of the lawyer to communicate or respond to client contact. So I don't know if Kelly has some information on that.
Yeah, I would agree. In the many grievances I see, it's probably a factor in 90% of them. And the client will, attach a string of text messages or emails that never got responded to, and just say that they're in the dark about what's happening in their case. And I'll tell you, it's something that really gets the Commission on Lawyer Discipline. It really gets their attention, and there's a whole organization called CAAP, that tries to jump in and remedy those situations and reestablish communication. But it is probably one of the quickest ways to having to defend yourself in a grievance, is not responding to requests for updates from the client. So you should just get in the habit on a periodic basis of giving the client updates, even if they're not requested, and certainly respond to your clients when they ask for updates. All right, that brings us to lesson number 8, which is don't make mistakes. Easier said than done.
Thank you. Good night. This has been fun.
Yes.
Yeah.
I include it because our malpractice carrier tells us that 10 years ago, mistakes were the cause of very few of their large malpractice claims. But over the years, it has now become the number 1 cause of large malpractice claims. And so they're really trying to figure out what the cause of that is and get lawyers to take actions to prevent mistakes. And I mean, there's a lot of things that they think are causing these mistakes. And I think a lot of these things are exacerbated by COVID and everyone working remotely. But, it's the increased ability to work on the fly, answer questions on your cell phone while you're at your kid's soccer game. You're just not going to give the concentrated thought and analysis to a question if you're doing something else, sitting in an airport, sitting in a doctor's office. If you can, just maybe tell the client, I'll get back to you this afternoon with that, and get to a place where you can really give it thought before you answer. Our clients expect immediate responses these days. Bill and I were reminiscing about the old days. I won't call them the good old days, but where you got the mail once a day, and all of your communications for the day came at that time, and you had at least a day to kind of think about them and figure out how you were going to respond. Then came the fax machines, and we got fax deliveries twice a day, so that kind of doubled your things you had to respond to. But now you get requests from clients and information literally 24 hours a day on our phones. And so even though clients expect an immediate response, your immediate response can be, I'll get back to you tomorrow, or I need to give that some more thought, and set their expectation for the fact that you need to take some time and give them a good answer. Also reviewing all your documents on a computer screen rather than on paper can lead to mistakes. If at all possible, before you send out the last version of a brief or a contract or something, print it out and look at it in a different format, and hopefully you will catch a mistake you might otherwise not have caught. All right, we're running out of time here, Bill. You want to hit number 9 quickly?
Sure, I'll hit number 9 quickly. It's fairly self-explanatory. There is a malpractice risk in taking on matters in areas of practice with which you're not familiar. It's sort of self-explanatory. This is a pressure on new lawyers and firms that are anxious for business. It is, again, difficult to turn down any opportunity to do legal work. But if you are not a probate lawyer, or you are not a tax lawyer, and you are presented with the opportunity to design an estate plan, that's probably something you shouldn't take on, right? That's what dabbling means, is to do a little bit of work in an area of practice with which you're not familiar. You will sort of know when that's happening, when you find yourself charging your client or needing to or wanting to for learning the subject matter, or figuring out how things happen that perhaps an experienced practitioner would already know. But it's a malpractice area of risk, particularly in areas of law that have specialized statutes or specialized procedures. And I'll leave that at that for this purpose. This is number 10 is really a follow-on to a conflicts analysis. It's just be vigilant in thinking about how changed circumstances affect your representation. The point here is that your representation of a client, Kelly's note says, think of it as a movie, not a snapshot. I think that's a good way to think about it. It's a continuum. It has a beginning and an end, but there's usually some distance in between. So nothing is static. So conflict analysis can't be static. And there are ways and times when a conflict needs to be reevaluated. One time is anytime there are new parties. If you're a litigator, new parties added to a case. If you're in a deal and new parties come into the deal, you ran your conflicts check 6 months ago when the matter began, but you don't update it. And it turns out this new addition creates a conflict you didn't see coming. It can be parties. We've had situations, I told Kelly, the reason the word experts appears here. We've had situations where we've represented, for instance, a doctor in a medical malpractice case 5 years ago. That representation is concluded. We're now on to representing some other doctor in a new case. And the plaintiff designates my former client doctor as an expert witness in the case. So there's a conflict issue that arose, not of my making, not of any insufficient work that our firm did, but one that jumps up and that you have to deal with. So It's important whenever there are new parties, experts, RTP designations, that sort of thing, even subpoenas to third parties that you need to be aware of in terms of keeping your conflicts updated.
All right, and 10.5 is just a little extra. This won't keep you from being sued or having a grievance against you probably, but it sure makes the defense of a grievance or a malpractice claim harder if there are unfortunate emails that get discovered along the way. And I have a full 1 hour presentation on don't send stupid emails, but it can be summed up in, don't send stupid emails. There are, as a general rule, just don't say things that you don't want to be cross-examined about 5 years in the future. And, just like everyone else, I am often tempted to fire off an ill-advised email about my colleagues or opposing counsel or the judge. And before I press send, I have kind of trained myself to think about how will I feel if this was blown up on a big poster board next to me at my deposition in 5 years? How do I feel about answering questions about it or having that as an exhibit to a motion that gets before the court? And usually that question will cause me not to send the email. I think this is a bigger problem with COVID because we're working remotely, and instead of just making that snarky comment to your neighbor next door, you're putting it in an email. But emails are forever. And as Bill said, paper is patient, but that can also be a bad thing if you've got a silly email in your file. So Bill and I both have lots of horror stories about emails that have turned the tide in litigation, and they're not necessarily outcome determinative, but they sure can make our job harder in defending you. If you've got an email in the file that suggests the team didn't know what they were doing, or calls your client an idiot, and then that makes them angry. I had a case where the client or the lawyer told the client that the judge was an idiot, and then the malpractice case ends up back in that judge's court, and of course they wasted no opportunity to put that email as an attachment to everything that they filed with that judge, which was not helpful. Take Bill and I out for drinks sometime. We'll tell you all the horror stories, but
Right.
For now, we'll just leave it with, don't send stupid emails.
The goal, I think, is to consider what you're writing, just think it is an exhibit. So I tell our lawyers, exhibits are best when they are one page and they fit on one page and they are formal, thoughtful, clear, and professional. And if you can meet that test, then it's probably okay to go. But otherwise, think about it twice, maybe 3 times.
All right. With that, Alexis, do you want to close us out here?
Yes, I believe there was just one question. Will this PowerPoint be available by email?
I think so. Probably, yes.
Just wanted to look out for there. Well, I think I can say for everyone who attended this presentation, that was very informative and very helpful, especially for younger lawyers, because you'll read the different cases and the statutes and all the guidance, but it's helpful to kind of put it in real world examples. So thank you very much, Kelly and Bill, for the time you spent on this well thought out presentation. It was absolutely wonderful. As I'm sure all of you know the drill, the CLE number is down in the chat under Catherine Zach's name. This is ethics credit, so make sure you will need to go to the website and record it yourself. This will be made available. It is recorded and will be made available. And for the small group session, our next I guess action item in this program is September. So small group session, there is no formal topic. So please feel free to speak with your mentors in your groups, whatever topic you think is necessary. We will be back for our final session. I can't even believe we're here, October 5th. At 12 p.m., Paul Wingo will discuss how to be a happy lawyer. So hopefully this doesn't scare you too much and you'll come back to become from scared to happy. Thank you all, and we'll see y'all back in October.
Thank you all.
Thank you.